Hi guys, welcome to our channel. I started making a series of videos on Indian Penal Code 1860 recently and I've uploaded a few videos. So I hope that you saw those videos, and if not, then please check them out. I request you to watch all the videos from our channel and also press the bell icon next to subscribe button to get all the updates on our upcoming videos. Also subscribe to our channel. Today this video is on chapter 3 of IPC, which covers section 53 to 75. Section 53 to 75 of this code tells us about the various kinds of punishments and other provisions related to them provided in IPC. I hope this video will be helpful to you. Indian Penal Code 1860, Chapter 3 of Punishments, Section 53 to 75. This video is part 2. In this video, I am going to discuss provisions from Section 65 to 75, as previous provisions have been discussed in the last video, and this will bring us to the end of Chapter 3. Section 65. Limit to imprisonment for non-payment of fine, when imprisonment and fine awardable. The term for which the code directs the offender to be imprisoned in default of payment of fine shall not exceed 1/4 of the term of imprisonment, which is the maximum fixed for the offence, if the offence be punishable with imprisonment as well as fine. Explanation. So for example, let's take section 379. Section 379 is punishment for theft. Whoever commits theft shall be punished with imprisonment of either description of a term which may extend to 3 years, or with fine, or both. So let's assume if a convict was awarded a sentence of fine only under section 379 for committing theft, and if he defaults to pay the fine, then he cannot be imprisonment in default of payment of fine for more than 274 days of imprisonment, as in this case section 379 provides that maximum punishment for theft is 3 years. Its 1/4 term will be 247 days at the maximum as per the section 65, which can be awarded on default of payment of fine. I hope this section 65 is clear now. Section 66. Description of imprisonment for non-payment of fine. The imprisonment which the courts impose in default of payment of a fine may be of any description to which the offender might have been sentenced for the offence. Explanation. There are two kinds of description of imprisonment provided in IPC. Those are simple and rigorous. This section provides that court can award imprisonment of any description which is provided for the provision relating to that offence. Section 67. Imprisonment for non-payment of fine when offence punishable with fine only. If the offence is punishable with fine only, the imprisonment which the court imposes in default of payment of fine shall be simple, and the term for which the court directs the offender to be imprisoned in default of payment of fine shall not exceed tile following scale. That is to say, for any term not exceeding 2 months, when the amount of fine shall not exceed 50 rupees, and for any term not exceeding 4 months, when the amount of fine shall not exceed 100 rupees, and for any term not exceeding 6 months in any other case. Explanation. If A commits an offence punishable with fine only, number 1, he can be imprisoned with simple description only. Number 2, if the fine is 50 rupees or less, the maximum imprisonment can be for 2 months. Number 3, if the fine is more than 50 rupees and up to 100, the maximum imprisonment can be of 4 months. If the fine is more than 100 rupees, the maximum imprisonment can be for a term of 6 months. These are the maximum term that can be awarded for non-payment or default in payment of fine. Section 68. Imprisonment to terminate on payment of fine. The imprisonment which is imposed in default of payment of fine shall terminate whenever that fine is either paid or levied by process of law. Explanation. This means that a person who has been imprisoned due to default of payment of fine will be released on the payment of fine by the court. Section 69. Termination of imprisonment on payment of proportional part of fine. If before the expiration of the term of imprisonment fixed in default of payment, such a proportion of fine be paid or levied that the term of imprisonment suffered in default of payment is not less than proportional to the part of the fine still unpaid, the imprisonment shall terminate. Illustration: A is sentenced to a fine of 100 rupees and to 4 months imprisonment in default of payment. Here, if 75 rupees of the fine will be paid or levied before expiration of 1 month of the imprisonment, A will be discharged as soon as the first month has been expired. If 75 rupees be paid or levied at the time of expiration of first month or at any later time while A continues imprisonment, A will be immediately discharged. If 50 rupees of fine will be paid or levied before expiration of 2 months of the imprisonment, A will be discharged as soon as 2 months are completed. If 50 rupees be paid or levied at the time of expiration of those 2 months or at any later time while A continues in imprisonment, A will be immediately discharged. Section 70. Fine leviable within 6 years or during imprisonment. Death not to discharge property from liability. The fine or any part thereof which remains unpaid may be levied at any time within 6 years after passing of sentence, and if under the sentence the offender be liable to imprisonment for longer period than 6 years, then any time previous to expiration of that period and the death of the offender does not discharge from the liability any property which would after his death be legally liable for his debts. Even if an offender has served his full term of imprisonment in default of payment of fine, that does not liberate him from the liability to pay the total amount of fine which the court had imposed on him. The framers of the Indian Penal Code were of the opinion that no one should be allowed to choose between suffering in his person undergoing imprisonment or his property paying the fine. The imprisonment which one has undergone in default of payment of fine does not release him from the liability to pay the fine. On the face of it, it may look a little harsh, but that is the mind of makers of the code, and they had sound logic behind this thinking. Consequently, the property of one who has undergone imprisonment in default of payment of fine could be taken by distress in order to release the fine. The fine remaining unpaid in full or in part may be levied at any time within 6 years after the sentence were passed. If, however, an offender is liable to imprisonment for a longer period than 6 years, then the fine may be levied at any time before that period expires. If the offender dies before paying the fine or before the fine is levied, his property would be legally liable to pay for his debt. Section 71. Limit of punishment of offence made up of several offences. Where anything which is an offence is made up of parts, any of which part it is itself an offence, the offender shall not be punished with the punishment of more than one of such offences, unless it is be so expressly provided. Where anything is an offence falling within 2 or more separate definitions of any law in force for the time being by which offences are defined or punished, or where several acts of which one or more than one would be by itself or themselves constitute an offence, constitute when combined a different, the offender shall not be punished with a more severe punishment than the court which tries him could award for any one of such offences. Illustrations. A gives Z 50 strokes with a stick. Here A may have committed the offence of voluntarily causing hurt to Z by the whole beating, and also by each of the blows which make up the whole beating. If A were liable to punishment for every blow, he might be imprisoned for 50 years, one for each blow, but he is liable only to one punishment for the whole beating. B. But if, while A is beating Z, Y interferes and A intentionally strikes Y, here, as the blow given to Y is no part of the act whereby A voluntarily causes hurt to Z, A is liable to punishment for voluntarily causing hurt to Z and to another for the blow given to Y. Section 72. Punishment of persons guilty of one of several offences, the judgment stating that it is doubtful of which. In all cases in which judgment is given that a person is guilty of one of several offences specified in the judgment, but that it is doubtful of which of these offences he is guilty, the offender shall be punished for the offence for which the lowest punishment is provided, if the same punishment is not provided for all. When an accused is held guilty of one of several offences, but it is not clear as to which one of these offences he is guilty of, he shall be awarded the lowest punishment, as if he is guilty of the least serious offence out of those sentences. If, however, all the offences are punishable with the same amount of punishment, the same sentence will be passed against him. The doubt is as to which of these offences he is guilty, and not as to whether he has committed an offence at all. The intention of the provision is that one who is guilty has been fully established should not go unpunished, on the ground that the penal provision in his case falls under uncertainty. In such cases where the question is as to whether he should be convicted for the aggravated or the mitigated form of the same offence, he must always be convicted for the mitigated form. There may be a case, for instance, where it is certain that either A or B has murdered Z, and also that whoever out of them has caused the murder has been actively and intentionally aided by the other in that murder, but who committed the murder and who aided is impossible to ascertain. Under these circumstances, both A and B shall be sentenced to the lesser punishment between the two offences. Section 73. Solitary confinement. Whenever any person is convicted of an offence for which under this code the court has power to sentence him to rigorous imprisonment, the court may by its sentence order that the offender shall be kept in solitary confinement for any portion or portions of the imprisonment to which he is sentenced, not exceeding 3 months in whole, according to the following scale, that is to say, a time not exceeding 1 month if the term of imprisonment shall not exceed 6 months, a time not exceeding 2 months if the term of imprisonment shall exceed 6 months and shall not exceed 1 year, a time not exceeding 3 months if the term of imprisonment shall exceed 1 year. Meaning of solitary confinement. Solitary confinement is a form of imprisonment in which an inmate is isolated from any human contact, with exception of members of prison staff. In India, maximum period of solitary confinement is 3 months, and it shall not exceed 14 days at a time. Relevant provisions of solitary confinement are section 73 and 74 of IPC. Let's understand this by chart. Term of imprisonment and maximum period of solitary confinement. If the term is less than 6 months, the maximum period of solitary confinement is 1 month. If the term is between 6 months to 1 year, the maximum period of solitary confinement is 2 months. If the term is more than 1 year, the maximum period of solitary confinement may be 3 months. Section 74. Limit of solitary confinement. In executing a sentence of solitary confinement, such confinement shall in no case exceed 14 days at a time, with intervals between periods of solitary confinement of not less than duration than such periods. And when the imprisonment awarded shall exceed 3 months, the solitary confinement shall not exceed 7 days in any 1 month of the whole imprisonment awarded, with intervals between periods of solitary confinement of not less than duration than such periods. This provision follows the principle that solitary confinement should be imposed only in intervals, since it produces a direct impact on mind of person undergoing it. Solitary confinement shall never be more than 14 days at a stretch. The interval between the period of solitary confinement must not be less than such periods of such confinements. In case of imprisonment of more than 3 months, solitary confinement shall not be of more than 7 days in any 1 month of the total imprisonment awarded. Here also the intervals between the periods of such confinement must not be less than such periods. Section 75. Enhanced punishment for certain offences under Chapter 12 or Chapter 17 after previous conviction. Whoever having been convicted by a court in India of an offence punishable under Chapter 12 or Chapter 17 of this code, with imprisonment of either description for a term of 3 years or upwards, shall be guilty of any offence punishable under either of those chapters with like imprisonment for the like term, shall be subject for every subsequent offence to imprisonment for life or to imprisonment for either description for a term which may extend to 10 years. Chapter 12 of offences relating to coin and government stamps. Chapter 17 of offences against property. If a person is convicted under any of the provisions of above mentioned chapters with imprisonment of either description for a term of 3 years or more, and after such conviction, if he got convicted again under the provisions of the above mentioned chapters with imprisonment of either description for a term of 3 years or more, that is second conviction, then he will get imprisonment of either description of imprisonment for life or either description of a term that may extend to 10 years. Thanks for watching. Please like, comment and share the video. Also subscribe to our channel. Keep coming back. Thank you.